Canada provides another example of how the Anglo-American legal tradition can accommodate litigation funding. As in the United Kingdom, Scotland, Australia, and New Zealand, Canadian courts have recently held that there is no prohibition against third-party litigation funding. While Canadian law is still developing in this area, there is a clear trend toward concluding that litigation funding fits within the common law tradition. Only a few Canadian cases have directly addressed the question whether a third-party investor can pay for a litigant's expenses, but those cases are unanimous in holding that there is no prohibition against it. The leading case was McIntyre Estate v. Ontario, a 2002 decision of the Ontario Court of Appeal, which held that contingency fee agreements were not contrary to the province's Champerty Act of 1897. According to the opinion in that case, advantages to the administration of justice from permitting regulated contingency fee agreements in the form of increased access to justice are compelling. Indeed, there is a strong case to be made that the continuation of a per se prohibition against contingency fee agreements actually tends to defeat the fundamental purpose underlying the law of Champerty, the protection of the administration of justice. The opinion also pointed out courts need to play an oversight role to assure any contingency fee agreements are fair to clients. This general approach was followed in Baynes v. Kinross Gold Corporation, a 2013 decision of the Ontario Supreme Court. Such judicial approval serves as a basis for the expansion of third-party funding agreements. According to Howard Borlaug, the founding partner of a Toronto firm, third-party litigation funding is almost certainly likely to increase. The companies doing this are very sophisticated. This is what they do for a living. They are not fishing for cases. This is particularly true in class actions where expenses are very high. In such cases, the plaintiff class may be able to go forward only if it has outside funding. Class action cases are not the only ones attracting third-party funding in Canada. Commercial cases are also developing as a growth area. In June 2015, in Schenck v. Valiant Pharmaceuticals, an Ontario trial court concluded third-party funding was permissible in single-party commercial litigation, as long as the funding arrangement did not provide for an excessive return to the investor. There, the court concluded an arrangement giving the investor more than 50% of any recovery would have to be amended to provide for a lower fee. Canadian courts are also grappling with the question whether and to what extent a party must disclose its third-party financing arrangements. One recent decision has explained why disclosure is unnecessary. A Saskatchewan court has held that the existence of the litigation funding agreement has no bearing, substantively or procedurally, on the defendants or the third parties, from whose pocket an adverse cost award is paid, is of no consequence to the defendants and the third parties. If you need help with litigation funding, call or email me today.